And for the YouTube proceedings, this is cause number 07-25-00002-CR, John Woody versus the state of Texas. And you are Mr. Libby, and you represent the appellant.
Yes, Your Honor.
And then Mr. Cavallero, you represent the state in this case.
Yes, Your Honor.
Okay. All right, go ahead, Mr. Libby.
Thank you, Your Honor. I have the pleasure of representing today appellant Mr. John Woody. I know him as Woody. Now, Woody.
Just 1 second. There's an issue with the clock.
I apologize.
No, it's not your fault. It's the operator. Any guesses?
Yeah.
What we need to do here?
And do one again.
Go ahead and clear.
2. And do 1.
Have they got it?
Yep.
They haven't always let me run the clock. That's just a recent thing.
We're gonna add a shot clock next.
Yeah.
Sounds good.
Okay, now you may go ahead.
Thank you, Your Honor. May it please the court, I do have the pleasure of representing Mr. John Woody on this appeal today. Ethan Libby on behalf of the Public Defender's Office. Now, Woody was charged with 2 counts alongside with co-defendant, his girlfriend, Latoya Skorich. Count 1 was a failure to act. This was an omission case similar to the first defendant. The second count was a commission. This was an alleged assault causing bodily injury to a child who, with the aggravating factor that child was under the age of 14. I'm going to start with count 1 because I think this is perhaps the most salient of the arguments presented in appellant's brief. In count 1, the state does concede on page 15 of the appellee's brief that there was no direct statutory duty for Mr. Woody to act because the state of Texas does not by law under the legislature punish boyfriends for not providing for their girlfriend's kids.
Isn't that statute changed?
As of my last reading, it has not. The state pursued that Mr. Woody had assumed care, custody, and control, and that was the nexus of their argument. I believe that statute is still correct, as I stated, Your Honor. And so the question here is going to become whether Mr. Woody had risen to the level of assuming care, custody, and control of AT. And we are, of course, of the position that he did not. I think the most salient case on point is going to be Florio versus State. Florio versus State has nearly identical facts as the case with Mr. Woody.
Well, did Florio versus State rely on a different provision of the penal code?
Florio versus State relied on the section of the penal code that states that there has to be a duty to provide care, just as with a parent or a step parent that had assumed that duty. However, I note that the care, custody, or control statute was enacted about a decade or more before that case came out. And based on a court's analysis, which would assume a hypothetically correct jury charge, that analysis would be included in the Florio decision. And so I believe that case law is still salient and on point for Mr. Woody's case. And so the question here is going to be, as the state asked, or the state assumed and argues, did he assume care, custody, and control? Now, the state relies on a case, Chiplin versus State. This is a Dallas case, 5th Court of Appeals. It is not binding authority on this court. However, it is persuasive. Now, in the Chiplin case, they tried to draw similar inferences between Mr. Woody and the defendant in the case in Chiplin. That Chiplin was a disciplinarian, that perhaps some harm had been done, that he encouraged the mother, the biological mother, not to provide care. But I think the facts in Mr. Woody's case are quite different than that of the defendants in Chiplin. While they were a live-in couple, let's say that the semi-truck was, for purposes, and the state's brief points out, a mobile home of sorts, that is not enough to rise to the level of assuming care, custody, and control. I think the state would point out that Mr. Woody had assumed disciplinary duties as the defendant in Chiplin. But I would point out that the mother in Chiplin, the biological mother who was responsible for the child, had actually attempted to stop the defendant in Chiplin from providing those disciplinary duties. The defendant in Chiplin went forward with it anyway, despite the protest, and after causing some apparent harm, refused to allow the mother to call the police. Now, the situation in Mr. Woody's case is quite different. Mr. Woody did provide primary disciplinary actions on behalf of Ms. Skorich. I don't think there's any argument as to that assertion. But there was no evidence on the record to support that Mr. Woody was not supposed to do so, that it was against protest, or that he was the one deciding when to discipline AT. Now, the defendant, Chiplin, took it upon himself to decide when to do so, and took it upon himself to do so despite protest. Mr. Woody's situation is a little bit different. In fact, a lot different.
Well, there is evidence that he provided discipline when he chose to do so, because the incident that may or may not have occurred in Arizona, when the child was pestering him, pinching him, attempting to bite him, he pulled over
Yes,
and spanked the child with a belt.
yes,
So he did have that, the mom didn't prevent that, that we know of. She went to the back of the vehicle. So didn't he have some control in that situation?
I may have been imprecise in my argument, Your Honor. It is unclear from the record that he is the sole decider of when AT is to be disciplined.
Well, does he have to be the sole decider?
He does not.
There is case law that says it doesn't have to be exclusive care, custody, and control.
Yes, precisely. It's a constellation of factors. There's no on-point factor analysis, and I think it is 2201 of the Penal Code that says essentially what the test is, that you had assumed responsibility for. It would be responsibility for providing nourishment, shelter, food, perhaps discipline is a part of that analysis. That's a part of the analysis, but it's not the whole thing.
Well, it's a totality of circumstances, right?
I believe so. I think that would be a correct analogy, Your Honor.
So what are the circumstances we have here? We've got the evidence that he was the one driving, that your client was the one driving the vehicle.
Yes, sir.
That your client was the one who made decisions at least part of the time on the road trip when to pull over for disciplinary purposes. We've got evidence that the day before the child went into the hospital, and we talked about from the previous argument that
Yes, sir.
that included time in El Paso. He spanked the child at that point. That at least appears to be some evidence that the events occurred in Texas at your client's hand.
I believe the record shows something slightly different. There is no question that there was a spanking that occurred on the border of Arizona and New Mexico. Ms. Skorich's testimony provides that. There is not, however, any evidence on point that says when any other spankings may have occurred. I don't believe there was any evidence to support a spanking in El Paso. If I missed it in the record, forgive me, Your Honor, but I don't think it's there. On point to when those bruises or the spankings may have occurred, Dr. Hansen, I believe, was testifying that you could not date a bruise, that some appeared fresher, some were not as fresh. There was petechiae that could be used to say maybe this is fresher than the other ones, but there's nothing to say that this happened in Texas. And I suppose this brings me to my argument on count 2, which is going to be that.
Well, before you go to count 2.
Yes, Your Honor.
The state also alleges the law of parties
Yes.
with regard to culpability under count 1.
Yes, Your Honor.
And you've not addressed that.
I can address that if Your Honor
Okay.
would like me to. So the law of parties, the state says that the jury was not charged on the law of parties as to count 1. They say under a hypothetically correct jury charge, the court can analyze as if they were. However, I think that's not correct, because a hypothetically correct jury charge under Pendleton, which the state cites, must be authorized by the indictment, and the indictment does not mention the law of parties in count 1 or count 2.
Is it a requirement to allege the law of parties in the indictment?
My reading of the statute and the case law is that is the case. That's my understanding. The court may have a different understanding, but I think it's incumbent upon the state to define the manner and means in which the alleged offense occurred to provide the indictment. It's their case. They can decide how to prosecute it, how to charge the defendant. And if they fail to indict them a certain way, I think that is incumbent upon them. It should be held against them. Now, as for the law of parties, assuming arguendo that my analysis on that, my conclusion is incorrect, I think for the law of parties to be relevant to this case would require under 702A A2 of the Texas Penal Code that Mr. Woody be acting with intent to promote or assist the commission of the offense. He solicits, encourages, directs, aids, or attempts to aid the other person to commit the offense. Now, with regard to count one, I think that Mr. Woody's case is still distinguishable from the first case, the Dallas case that I had mentioned, which was Chiplin. Yes, Your Honor, Chiplin.
If the evidence shows that the fit, to lack of a better word, that the boy was throwing was related to the desire for water, and your client enforced that through disciplinary measures, is that not assisting and encouraging?
I don't think it is. I think the evidence on the record does show that it was in response to the actions of hitting the driver in a very large vehicle, which is extremely dangerous. This is why I briefed the court on the facts of a prior trip in which they were in an accident. So they were thinking of that, and that's why perhaps that occurred. Now, the defendant in Chiplin, specifically against protests from the mother, hit the child, and when the mother sought to stop him, he would not stop. And when she sought to call the police, he took her phone and told her not to. He then told the mother, tell them it was a football injury. Mr. Woody didn't do any of that. He didn't take Ms. Gorge's phone. They made calls to a doctor. I think investigator David Sanford's testimony provided that on the record. That was not stricken.
Well, can we infer from the testimony that he continued to drive his truck to drop off these various loads because he was under a deadline to do so, and that he assisted in her failure to provide the proper nourishment?
I think that was incumbent, of course, upon Ms. Skorich, being the biological mother. Mr. Woody was stuck to a deadline. Mr. Woody has to make his drops when he has to make his drops, or else he can't do his job. I have to submit my briefs by the timeline, or else I can't do my job. And just because I bring a girlfriend and her child along with me to the office to submit that brief isn't going to mean that during the course of that submission and applying to that deadline, that I think that's a false analogy. And I think that, am I answering your question, Judge? I don't think I am.
All right.
I've got a related question.
Yes, Your Honor.
Not really about the facts of the case. It appears that there's some conflict in the interests of Ms. Skorich and Mr. Woody, and I'm curious how they're able to be jointly represented by your office.
And what were those conflicts, Your Honor? That perhaps the defendants, co-defendants would point fingers?
Well, this example that we've got right here, that maybe that appears, as far as Mr. Woody is concerned, that it's Mr. Woody's interest to say, I didn't have anything to do with any of the disciplinary measure, or didn't have anything to do with the care and control with regard to feeding and sustenance. But with regard to Ms. Skorich's position, she's saying, I didn't have anything to do with regard to the discipline. It may not matter for purposes of this argument, but that's my concern, is that you've got a potential conflict with those two clients, and your group is representing both.
So I think that there perhaps on its face appears that would be the case. I don't think it is. I think that Mr. Woody can prophylactically separate him and just say, look, I don't have a duty. I did not assume care, custody, and control. I don't have a duty to provide. Come along with me. That's great. There's case law where similar defendants similarly situated were acquitted by the Court of Criminal Appeals because of the law. Now, as for the spanking, I think that, well, just like that of the defendant in Florio, that the defendant in Florio was a primary disciplinarian, does not necessarily absolve either of guilt or blame, but it's going to be fact specific. And I think in this case that Mr. Woody's situation is that more of the defendants in Florio than of Chiplin's. And I think were the facts different, were Mr. Woody's situation closer to that of the defendants in Chiplin's, which again isn't binding authority, but for persuasive argument purposes, I think it's fundamentally different based on the facts.
I want to go back to your very, very first point. You were describing the facts for Woody are different from Chiplin. And
Yes, Your Honor.
you were almost there. I think you were trying to argue something that Woody's facts don't amount to assuming the duty. Can you finish? I want to hear what you were about to say on that.
Yes, Your Honor. Now, the defendant in Chiplin had assumed, was a live-in boyfriend. This was not a mobile truck. He had stayed, I believe, for 10 days consecutively with the mother and the child leading up to the incident of the defendants in Chiplin's. He had more than provided disciplinary duty. He had went above and beyond, not in a good way, but in a bad way, with providing discipline for the child in that case. I think similarly, he was responsible and did help with, I think, and forgive me if my reading of Chiplin isn't memorized, helped pay bills, provide shelter, did some of those things. And Mr. Woody did as well. But I think because of the way that Mr. Chiplin took control of the situation, he took reins of that child's upbringing. And on top of that, stopped the real mother from providing any kind of care for that child.
Yeah, he provided medical, aspirin or something.
Yeah,
And
ibuprofen, I
then he
believe.
prevented the child's mother from, calling 911. He took her cell phone.
Mhm.
I mean, he took active steps.
And I think that's going to be the clear distinction between Mr. Woody's case and that of the defendants in Chiplin's, is Mr. Woody, they called him Trucker Woody. He was a father-like figure for AT, but that's not enough to say that you are taking control of this child's upbringing and life, like the statute in 2201 seems to purport, from the reading of the statute.
Well, they were living together since the mother had the child for about 6 months. They were going on trips, his work trips.
Mhm.
The child was being educated in the truck, schooling. And discipline and eating.
I believe, I'm sorry, Your Honor, did you? Well, I believe Ms. Skoric's testimony is on point, that Ms. Skoric never once said, and she was the only witness from inside of that truck that did testify, that she was the one that was responsible for giving AT the water. I think an ounce, every ounce, whatever it was, a bottle of water, rubbing the lips to make sure that the moisture was there, that she was providing, let's say, medical, or if it doesn't rise to that level, motherly care for the child, that Mr. Woody didn't quite take on those roles. It doesn't say anywhere in the record that Mr. Woody was responsible for changing diapers, for administering medication, or anything like that. While they were within his truck, and we'll call it a residence for purposes of this argument, I think that's fair. I think that is not enough. And just like that of the defendant in Florio, I think that does not rise to the level of having a legal duty to act to protect AT, to provide medical care for AT. Although he did, when they were at the Lovestruck station and they saw that AT, this is the Lovestruck station in Deaf Smith County in Hereford, that when they did see that there was an issue, they immediately stopped and brought him to the hospital. That he rose above and beyond the level of merely a boyfriend, and that was of his own will. That wasn't because the law was forcing him to. Now, that the defendant in Chiplin, I think they said that he did essentially assume care, custody, and control based on the actions, I think specifically with causing the harm, and then not providing, and not only not providing, but actively preventing aid to be given to that child. Mr. Woody's situation is diametrically opposed to that.
Do you know Ms. Skorich ever testified using the word we did this, we did that?
She may have.
Would that not allow an inference that we met Mr. Woody jointly with her?
I think it can, Your Honor. Of course, the jury is free to regard or not regard any testimony that is presented to them. I think that, just like the case law that says that just because someone is referred to as father or a parent is not enough to de facto say, it's a constellation of factors. It is a legal conclusion based on facts, and it's going to be based upon a constellation of factors. And so I have two cases here. I've got Florio from the Court of Criminal Appeals. I have Chiplin from the Dallas Court of Appeals. The facts are very different, and it's going to be a question of, was Mr. Woody's case more similar to that of Florio or that of Chiplin? And my stance is that it was that of Florio. Now, of course, changing gears just a little bit, I know that my jurisdictional and venue arguments are quite similar, if not identical, to that of the first defendant, Ms. Skorich, that the testimony provides on the record the only possible place that any alleged spanking occurred, I believe, was on the border of Arizona and New Mexico, which is meaning that this case should not have been litigated in Deaf Smith County, Texas. Now, going back to the doctor's testimony about layering of bruises, about not being able to date the bruises, petechiae and weeping, showing that bruises may have been more fresh. That might be true. And I'm certainly not a doctor, not that kind of doctor. I'm not going to to argue that assessment. But just because something is fresher or less fresh than another does not mean you can date it. And I believe that they were in Texas for about a day from the time they entered El Paso until they reached Hereford, Texas.
What about the testimony that they were in Texas several days before they were in Texas for the second time?
Yes, so the trip was going to start on September 3rd. They leave Springdale, Arkansas. They get to Denison, Texas, and then through to El Paso. Then they go to California and arrive back to El Paso on September the 9th. So they were in Texas for a period of time, but there's no evidence in the record to support that a spanking happened during that time frame when they were in Texas.
Is there an inference could be made that that bruising of the child occurred
In
in
Texas,
Texas?
I think it's a guess more than an inference. An inference would be based on testimony, whereas a guess is just, I see that something happened. We've got to punish someone. Let's say it happened in Texas and we'll be on our way. I just think it's stacking an inference upon an inference. And I think for legal sufficiency for a jury verdict to stand, that's just not enough. It has to be based on something in the record. If there was something in the record, I don't think this argument would be in my brief. The evidence is viewed in the light most favorable to the verdict. The state has a powerful, powerful thing in their possession, and that is a guilty verdict. But I think I have the law on my side that says that if the verdict is not based on anything in the record, that the proper remedy would be to either vacate the judgment or to remand for further proceedings consistent with the Court of Appeals' opinion. And I have 2 seconds left. I would entertain any questions from the
I
justices.
guess what would those further proceedings be? I mean, you've kind of had the benefit of a double jeopardy argument if he's retried. So what would those other proceedings be?
Honestly, Judge, I'm not sure. Perhaps, I don't know. But I think to vacate the judgment will be the most appropriate remedy based on the facts in this case.
Any further questions?
No.
Okay. Thank you.
Thank you, Your Honors.
Please, the court, counsel.
Counsel. Hang on a second, I've got another issue with the clock. Then I had to redo this every time. Now you may go.
Thank you. Just like appellant's counsel said, the venue and the jurisdiction issues that were presented are pretty much similar to what the Mrs. Skolrich's appeal. So I'm not going to cover that much. I'm not going to spend that much time onto that. I do want to point out that I think one of you had said it before, that there is a bit of a difficulty that arises from determining venue and jurisdiction, mainly because it relies on the defendant to determine that. I think it was you, Justice Doss, that had pointed that out. And, the appellant's argument for that is we're relying on Mrs. Skolrich's testimony that the assault that had occurred, the potential spanking, had occurred somewhere between Arizona and New Mexico.
Well, and while I made the acknowledgement a while ago, I'm also aware of the fact that the state's the one that chose to pursue a path of omission as its theory of the case instead of an act of commission. Certainly an act of commission could be determined on a certain date. Omission, we don't really know when something rose to a certain level, right?
Yeah, exactly. And in my brief too, I think we discussed it, the Court of Criminal Appeals has said omission is really just can be a continuous act. It can take a matter of days for a result to occur, or maybe the result have occurred, but it's still ongoing. But that's pretty much the point I wanted to make with the venue jurisdiction. Again, my argument's the same as Mr. Stroud's. As to the reply to the point of error number 1, I believe that the appellant's reliance on Florida versus state is flawed. I think Justice Parker, you pointed out that Florida versus state, they were talking about a statute that didn't include the assumption of care, custody, or control at that point. And that was really the gist of Florida versus state, was that the defendant in that case was charged and convicted of that offense, injury to a child, but it didn't allege assumed care, custody, control because the statute didn't have it at the time. And the appellant concedes that in 1989 they amended that. They amended the statute to include the assuming care, custody, control. So I don't think Florida versus State is at all relevant. You know, the fact pattern is real similar, but I think the reasoning behind Florida versus State isn't at all applicable to this case.
What evidence do you believe supports a finding of care, custody, or control?
Well, Judge, we have testimony in this case from Mrs. Scoridge. You know, the child does refer to Mr. Woody as, you know, Daddy Woody, Woody Trucker. We have testimony that, you know, there was bedding, there was food, there was water, there was a refrigerator, there was even a toilet. There was a small portable urinal and a portable toilet inside that truck, the semi truck. And the semi truck was owned by John Woody, and probably more than likely the only person that was capable of operating that truck was John Woody. And so we have him providing shelter and honestly access to food to the child. We also have him as the primary discipline. I think that's uncontested. That's uncontested in the record that he was the primary disciplinarian of the child. And we know that he was actively doing that during this trip that led to, you know, his arrest. We also have statements from him in his brief that, you know, in his brief, I think at page 31 and 32, he concedes that appellant provided shelter and food and water, and that he may have fulfilled those roles on occasion. And I think Justice Parker pointed out that there is case law that says that didn't need to be exclusive. That regardless of Mrs. Scoridge's presence throughout the entire trip, Woody could have fulfilled some of those roles along with Mrs. Scoridge. I think that's kind of analogous. Some of us are parents, some of us are married, some of us have co-parents. I don't think any one of us has, or any of y'all would say, I have exclusive duty to discipline my child. I think you would, you can have the other parent do that as well. I think that's a good analogy for that, for the reasoning behind that instance. So we have those factors, and now the court, you know, we think that the state argues that this is the Jackson versus Virginia standard, that, you know, it's a legal sufficiency of whether or not a rational trier of fact could have found that there was sufficient enough evidence for that. I think based off of the totality of the evidence that they could have found that Mr. Woody had assumed care, custody, control of the child. And I think and certainly they did so with their verdict.
I want to talk about the jurisdictional
Sure.
just for a moment. In the state's argument in the first case, the state reminded us of the definition of bodily injury, and it includes pain.
Yes.
To say, hey, well, the kid's in pain at the hospital. What if Woody had burned the child in Clovis, New Mexico, with the iron rod, okay? And the closest hospital is Hereford, and they just transport the kid to Hereford? Could you bring a claim to injury to a child in Hereford based on that?
I think that kind of goes to my first point, you know, Justice Doss is like, that kind of relies on the defendant to do so. You know, he burns the child in Clovis and then takes the child to the hospital in Hereford, or that's the closest hospital. We're kind of, I think that would be against societal interest to just rely that, you know, to have an injury that happened in another state, and it so happens that the hospital happens to be somewhere else. I think that would be, we're putting too much reliance on the defendant's actions for that.
Does it turn on whether it's an act of commission or an act of omission? Under Justice Yarborough's example, if the act of burning occurred in Clovis, the act of commission occurred then outside the state of Texas.
Well, I think probably what I should point out too is I think in the statute for it, I think 106 says that an territorial jurisdiction over an offense exists if the conduct or a result that as an element of the offense occurs inside that state. You know, the element of the offense is the result, that as an element would be bodily injury or serious bodily injury. I think in that case, a burn would be serious bodily injury, or could be. You know, that definitely occurring in the state. You know, he's suffering from those burns while he's in the state. And in this case, in this particular case, he's suffering from serious bodily injury from the dehydration. And then we have evidence of the petechiae, the weeping from the wounds. The doctor said that the wound appeared to be superficial, like it had not even begun the healing process. You had the officer Medell, who stated that the injuries appeared fresh. You know, he's suffering from that serious bodily injury.
That gives the state of Texas really broad criminal jurisdiction. It would presume that an act could occur anywhere else as long as pain occurs in the state.
Right, that was my exact follow-up question, is it almost sounds like it doesn't matter in the state's mind if it's commission or omission. As long as they are suffering pain anywhere in Texas, it counts.
Well, I think I would agree with that. I think because the statute, the way the statute is read, at least my understanding of the statute is that, you know, bodily injury is an element of the offense, and they're suffering from bodily injury or serious bodily injury within the state of Texas. I think that part of it. And I think the
I
relevant,
could shoot somebody in Clovis, bring them to Hereford could prosecute them. Because they're suffering pain.
I think so. I think I think there is just an alternative too. I don't know how New Mexico does it, but say if I shoot somebody in Desmond County and then they go over to neighboring Parker County, and you know, that would they discover that he was suffering from bodily injury, serious bodily injury because of that shot. I think either or of those places could be, you know, proper jurisdiction.
What
or
would be the
proper venue.
purpose of the jurisdiction statute then? If it could occur, if Texas could essentially extend its arm of the criminal law that far?
The purpose of it?
Yeah, why would we need a jurisdictional statute at all? If
Well-
it simply said, hey, as long as you can bring an injured person here in Texas long enough, then the jurisdiction's been met.
Well, I'm sure it might be, you know, for this case might be a good example of this. What we have in evidence is that they were traveling cross country in their semi truck. And part of that, you know, they were traveling to multiple different states during that journey. And again, this goes to, again, we're giving them a little too much favor when we say that, you know, it's really up to them, depending on where they take the kid to the hospital, or whether they go to the hospital, or whether or not the law, you know, they go law enforcement or anything like that, and that determines jurisdiction. I think the whole point of that part where, you know, the legislator intended to, for the element of the offense is to occur, is to give us that option for these transient type of offenses.
Maybe so. I would think otherwise I would have concerns about how far Texas law could go. I was thinking of an example, for example, it's consumption of marijuana is legal in the state of New Mexico. If it's legally purchased in the state of New Mexico and somebody is injured in the state of Texas, and they're not, you can't prove that it's under the influence, you could still prosecute the fact that it was sold. I mean, that would be criminalizing conduct that would be legal in another jurisdiction.
Yeah, I don't think that's a close enough analogy to that, but I understand the concern, but I don't think that's a close enough an analogy to this case. And so, you know, the territorial jurisdiction is whether or not an element of the offense occurred in this state. And so definitely, you know, an element of the offense occurred in the state, and that was serious bodily injury and bodily injury. And we kind of know that, you know, it's been discussed at length, I think, that they arrived in Texas at a certain date. They arrived, and then they left Texas, then came back from El Paso. As to the omission part, you know, we know that, you know, dehydrating takes a while. The doctors testified that it takes a while. That dehydration could be an irrational inference that dehydration probably started on that trip. You know, Scores testified that they were kind of scared giving him water because he would wet his bed quite often. So a rational inference could be that they started not giving him enough water throughout that trip. And most of that trip happened in Texas. And then when they come back to El Paso, um, you know, as to count two, we have the testimony regarding um, we had testimony regarding the petechiae, the weeping, the layers and layers of bruises, that they appeared fresh. The jury could have made a rational inference that that happened in Texas as well. I think that that satisfies that jurisdictional question. And I think the question Justice Yarbrough was trying to get at was the venue part of it as well. You know, why DeSmith County should be it. Well, again, it's the same type of analysis as whether or not an element of the offense happened in DeSmith County. And again, he was suffering from bodily injury and serious bodily injury in DeSmith County. And even if the court doesn't rely on that, the court could also rely on the extradition part. You know, without a doubt, they were extradited out of Nebraska and brought to DeSmith County to be tried. They were indicted in DeSmith County.
Well, Potter County could have prosecuted this,
Prosecuted, no,
and he's suffering.
he's
pain
suffering
at
from bodily injury.
Northwest.
I would agree with that. I would agree. But even if the court doesn't decide whether or not that venue is applicable, you know, again, like Mr. Strauss stated, is subject to a harmless error analysis. And I don't think that the defendants or the appellants, either of them, were harmed in any kind of way by having it tried in DeSmith County. They were able to put on a defense. They put on a defense at trial that the injuries were probably caused from that Ehlers-Danlos syndrome, that, you know, they tried giving him water. They tried
So this goes back to the hypothetical appellant's counsel gave another one where they're care flighting them across the country. Say they get them Northwest, and Northwest says, I can't fix this. We got to send them to Houston, where Woody's never even been, and he's in pain, the kid's in pain in Houston. Houston could prosecute this.
I guess so. I guess keeping in line with my argument that an element occurs, you know, I think Houston will probably, it could be a place that would have venue at the very least.
What do you have on the second argument with regard to the assault? He was convicted of assault. What evidence is there of an assault taking place in the state of Texas?
Well, I think again, the petechiae, the weeping, the doctor saying that the injuries appeared fresh, they appeared superficial, that they weren't quite healed yet.
I don't remember any time in the record when any medical provider or anyone else said it could have happened in the last 2 days. I think at one point they said a couple of days or something, but if I remember from the first argument, at least Ms. Skurrich's counsel said that wasn't what the record said. So I'm trying to make sure I understand.
I think a rational inference could be that those happened either just recently or in the past day. You know, they were in Texas and El Paso the day prior to. And so, you know, based off of that healing process, I think the jury could make a rational inference that an assault had occurred in Texas. And then also,
So the element or the evidence supporting the element of the assault occurring would be the bruising. The element supporting timing of when the assault occurred would also be the bruising.
the bruising, the petechiae, you know, the little white spots that indicated that it just happened. The weeping off of it, you know, I think the Dr. Hansen described it as kind of like a moisture to it. I'm sure some of us have been bruised before, some of us have been badly bruised. You know, there's kind of a bit of a moisture when that happens.
Did Dr. Hansen testify based upon that moisture that allowed him to conclude that it happened recently? I mean, happened within the last day or so, or?
I don't think he gave a specific time frame for it, but I think he said it happened recent enough. See, they did it happen recently. So I think
Because if I remember what he said,
yeah, so on think it would be, I have it under here as 4 in the 4, page 118. Dr. Hansen observed petechiae and weeping from some of the injuries as well, which served as an indicator that these, and in quotation marks, just happened, and that the tissue damage is still very official. So he said just happened, that the injuries just happened.
How are we supposed to analyze that? Are we just supposed to, in light of the, you know, the guilty verdict, assume the jury determined that that meant in the last 24 hours?
I guess that would be, a rational inference. I think that would be a rational inference, that it just happened. A jury could take that statement and say, well, maybe it just happened before they brought him to the hospital. Or it just it could just happen an hour or 2 or 3. I don't think there's really a need for a specific time frame for that. I think,
Well, except outside 24 hours, outside of Texas, right?
yeah, outside of 24 hours, it could have been outside Texas, but it said just happened. So it could be that a jury could rationally make it happen in Texas. So I don't think there's a need really a necessity to make it a specific time frame to limit that to 24 hours. I think I only got about a minute left. I think I've covered most of it. Do you have any questions? Any more questions?
Let me test the last thing you said. If that were the case, that could be the same argument that prosecutors could make in New Mexico or in Arizona as well, right? To say, well, we're not saying it happened here, but we're not saying they can show that it didn't happen here because of the recency of the bruising. That gets us back into the jurisdictional
Yeah.
problem.
And I think the standard, the Jackson versus Stange says that a rational trier of fact, can make that rational inference. So it's really, and it's the light of the favor of the verdict. So clearly the jury thought that, that statement, it just happened, and also the rest of the evidence saying that there's weeping, the petechiae, the bruising, some of the bruising appeared more fresh than the other ones. They could have used all of that evidence to infer that the assault happened in Texas.
You have 8 seconds left.
Yeah, thank you. I appreciate y'all's attention.
Libby, you have a 5-minute rebuttal.
Thank you, Your Honor.
And once again, the clock. I guess. Okay, there you go.
Thank you. These are both very, very complex arguments. They touch on issues that affect the most fundamental of our criminal justice system, the most fundamental aspects of that criminal justice system. I think ultimately it's going to come down to, for count 2, did the spanking happen in Texas? And there simply is not enough evidence to support that. It would be a guess, and I think the state does not use the word guess, but I think the state essentially says, as to count 2, that it's enough to assume that the spanking happened in Texas based on the petechiae. However, the state's own witnesses kept testifying ad nauseum, we cannot date a bruise. We don't know when it happened. We can say that one might be more recent than the other. That's still an inference. And so taking a doctor's inference and another doctor's inference to then infer that a spanking could have happened within the last 24 hours, I simply don't think that's enough. And so then it becomes a question of prosecutorial overreach. Can the state prosecute a spanking that happened outside the state of Texas? I think for the act of commission, the answer to that is no. I think another
irrational for the jury to say that it happened in Texas.
I think it would. I think to beat the Jackson standard, which is, I think, higher than that of beyond a reasonable doubt, is what the case law says, is that a rational trier of fact could not assume that the spanking happened within the bounds of Texas based on what's in the record. We have one person saying happened on the border of Arizona and New Mexico, and then another person saying, I don't know where it happened. And I don't think that's enough based on what the record actually shows in this case.
And this is venue you're talking about?
I think it's jurisdiction. Possibly both. The two are tightly overlapped.
Well,
I think it may
except,
touch
You
both.
know, there's ponderance of the evidence
It is a preponderance standard. Venue
on
is.
venue.
Yes, Your Honor.
There's a question though on territorial jurisdiction, whether that'd be beyond a reasonable doubt.
Let me ask you a question that I asked you a while ago, now that I thought about it further. If we were to say there was no jurisdiction over the active commission, there's no double jeopardy issue there, is there?
I'm sorry, could you ask the question again, Your Honor?
We said there's there's insufficient evidence to support jurisdiction over the assault. Your client would not have the same double jeopardy protections that he would if we said there's no evidence under your sufficiency of the evidence argument.
I think
Because that would
that's
be
possible.
procedural, right?
Your Honor, I think that's possible. I think it's, venue is not an element of the offense. Jurisdiction is not charged as an element of the offense. I would have to look at the analysis on
It's
that.
just the power of the court to hear the case, right?
I believe so. And I think that's more fundamental than that of being an element of the case, essentially. Perhaps the better case, the better place to try this would have been Arizona or New Mexico. It was not tried in Arizona or New Mexico. They happened to stumble into Hereford, Texas, and that's where the case was tried. I think jurisdiction is more fundamental than that of being an element of the case. Because without jurisdiction, the court has no authority to do anything. And I think that would be correct, that because the court had no authority to do anything, perhaps the case could be tried in a different state. But that would not be a question for me today or us.
Had jurisdiction over the act of omission or the alleged act of omission. Can it bootstrap jurisdiction on this charge too?
Now, for the act of omission, I think that's a little bit different than that of the act of commission. I think the court agrees with that assertion. For the act of omission, again, I would rely, fundamentally on the fact that Mr. Woody didn't have a duty under the law to provide care. Now, as for jurisdiction or venue, being a result of conduct offense, I think perhaps jurisdiction could be proper. I don't know that venue might be. The fact that the state really seems to hang its hat on the fact that they were extradited here. My dad lives in Illinois. He's never been to Potter County, Texas. If somehow the state happens to get an indictment and happens to get a warrant for the arrest of my father, and they bring him to Potter County, Texas, well, he was extradited, there must be venue here. He has no contacts. I think the question was about the long arm was brought up, and I don't want to.
That may raise a due process argument.
And I think we did.
But the statute says what the statute says.
The statute says what the statute says. I think applied to these facts that it is effectively a violation of due process, because the person being extradited, in my hypothetical, my dad who lives in Illinois, that would be fundamentally unfair to bring someone to a state or a county where he's never been to stand trial. And I think
My point though is you didn't raise a due process argument on why extradition couldn't be used here.
I may have tangentially mentioned it or by inference mentioned it in my brief. It was not an articulated point in my table of contents. Your Honor, I think I did bring up. Well, I think my notice argument came under a different argument, but I think that the logic would apply to that as well, Your Honor. And I see that my time is up. 5 minutes goes by quick when you're
I don't
up here. Thank you very much, Your Honor.
Thank you. The case is submitted. This concludes our arguments. Thank you, Deputy. And the court will be in recess.
All rise.